Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Sanchit Gupta vs. Deputy Commissioner of Income Tax, pronounced by Delhi Tribunal on the 21st of May 2026. The assessee, Sanchit Gupta, purchased an immovable property along with two co-owners for a consideration of Rs 30,60,000. He deducted and deposited TDS under Section 194 IA at 1%, Rs 30,600, via Form 26 QB on the 28th of August 2023. However, the seller's PAN, BXQPAO811B, was not linked with Aadhaar, rendering it inoperative under Rule 114 AAA3, effective from the 1st of July 2023. The CPC, TDS processed the return under Section 200A on the 29th of August 2023, applying TDS at 20% under Section 206 AA, raising a demand of Rs 5,87,210, including interest. The assessee appealed to the CIT, who dismissed the appeal, holding that the statutory mandate of Section 206 AA read with Rule 114 AAA3 was clear, and subsequent linking of PAN with Aadhaar would not retrospectively validate the transaction. The tribunal acknowledged that under Section 206 AA1, the initial burden on the deductor is to obtain the PAN of the deductee. The assessee had discharged this burden by obtaining the seller's PAN. However, Section 206 AA6 deems that a PAN is not furnished if it is found to be invalid. Rule 114 AA3, effective from the 1st of July 2023, provides that an inoperative PAN shall be treated as non-furnishing of PAN for all purposes of the Income Tax Act, 1961. The tribunal observed that the department's system, Form 26 QB utility, did not flag any pop-up or message when the inoperative PAN was entered or when TDS was filled at 1%. This was a critical factor. The tribunal held that the department was equally responsible for not alerting the assessee about the inoperative status of the PAN. The assessee had acted bona fide, and there was no deliberate defiance of law or conscious disregard of obligations. Drawing analogy with Section 40, IA, and the Delhi High Court decision in CIT vs. Ansal Landmark Township Private Limited, the tribunal held that if the deductee, seller, has declared the sale income in their return of income and paid taxes thereon, no higher TDS liability should be imposed on the deductor. The tribunal emphasized that the purpose of TDS provisions is to ensure tax collection, not to penalize the deductor for a technical breach when the revenue is not lost. The seller linked her PAN with Aadhaar in August 2024, after paying a late fee of Rs 1,000. The tribunal noted that the extended date for linking was the 31st of May 2024, but the seller linked only in August 2024. Despite this, the tribunal held that the subsequent linking, coupled with the department's system failure, warranted a pragmatic approach. The matter was remanded to the AO to verify whether the seller had declared the sale income and paid taxes. The tribunal directed the AO to verify whether the seller, deductee, has filed her return of income for assessment year 2024 to 25, whether the sale consideration has been declared and taxes paid. If so, no higher TDS liability should be imposed on the assessee. If not, the AO may proceed in accordance with law. The ITAT's decision in Sanchit Gupta vs. DCIT is a significant ruling that balances statutory compliance with practical realities. The tribunal recognized that while Section 206 AA read with Rule 114 AAA3 mandates higher TDS for an operative PAN, the department's system failure and the bona fide conduct of the assessee cannot be ignored. By remanding the matter for verification of the deductee's tax compliance, the tribunal ensured that the revenue is protected without unjust enrichment. Question: What was the key legal issue in Sanchit Gupta vs DCIT? Answer: The key issue was whether the assessee, deductor, could be held liable for short deduction of TDS under Section 206AA when the seller's PAN was inoperative due to non-linking with Aadhaar, despite the department's system not flagging the error. Question: What did the ITAT decide regarding the higher TDS demand? Answer: The ITAT allowed the appeal for statistical purposes and remanded the matter to the AO. It held that if the seller has declared the sale income and paid taxes, no higher TDS liability should be imposed on the assessee. Question: How did the ITAT view the department's role in this case? Answer: The ITAT observed that the department's system, Form 26QB utility, failed to flag the inoperative PAN, making the department equally responsible for the compliance gap. Question: What is the significance of the Unsal Landmark Township case? Answer: The ITAT drew analogy from the Delhi High Court decision in CIT vs Unsal Landmark Township Private Limited, which held that if the deductee has paid taxes, no disallowance under Section 40A IA should be made. Similarly, here, if the seller paid taxes, no higher TDS liability should be imposed. Question: Does this ruling mean assessees can avoid higher TDS for an operative PAN? Answer: No. The ruling is fact-specific. It applies only when the deductee has declared the income and paid taxes. The assessee must still comply with Section 206AA, but the department must also ensure its systems support compliance. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, TaxPundit.org. If you have any questions, feel free to write to us at TaxPundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.